Hi and welcome to LawSikho. My name is Amish Aggarwala, and today I want to talk about the issue that a lot of lawyers face, where whatever sphere of practice they are in, they choose to focus their strategies always on those particular spheres and choose to ignore the others. For example, just yesterday I got a call from a lawyer friend who told me that he got into a little bit of a dispute with a neighbor of his. I will not go into details, but what the lawyer did was he immediately called up 100 number, he went to the local police station and he filed his complaint regarding all the offenses that had been committed. The person then called me up and asked me about any discrepancies or any deficiency in his work that maybe he could improve upon, maybe he could do a little more to get adequate relief and to ensure that the accused person, the opponent in this particular case, is brought to justice. This thing did not come to his mind at all, that this, of course, there is a criminal complaint. Unless you go to court and you file your complaint under section 200 before the court itself, you will leave the entire investigation into the hands of the police, and there is not much that you can do in this in particular investigation. But when you want things to move a little fast, a little in an expedited way, what you can do is do some things which are in your control. One thing, of course, is to file your own complaint, give your evidence, but again, with that, there is the other issue is that it takes a lot of time for that to happen, perhaps a couple of weeks. So I suggested to my friend that he should also immediately file a civil suit for injunction as well as damages for for the actions of the opponents. A simple civil suit for injunction, if filed before the court, whichever district court it is, the matter will be listed perhaps the same day itself or the next day. The judge issues notice immediately. Depending on the urgency of the matter, the judge can give you a date anywhere between 1 day and 30 days. And if you say that there is an extreme urgency in my matter, you can say to the judge, give me thus the orders, I'll have it served upon the respondent, and the respondent can come urgently and can contest this particular case. If that happens, for my friend at the very, I don't know if he has filed this case or not, but if he would have done this or if he has done this, the timeline would be he goes and files the case, the matter is taken up the same day or the next day before the court. The civil court, usually when a cause of action is made out, the court issues notice, and depending upon the urgency of the situation, summons are delivered upon the defendant, who has to then come to court. There is also the aspect of filing the written statement within 30 days. So the person has to now immediately, the opponent now has to immediately hire a lawyer, present his facts. When there is concrete evidence against the opponent, it becomes very difficult for him to contest it or to in any sort of way deny it. And when the matter comes before the court, it becomes extremely difficult for the defendant, the opponent now, to present a good case and get a favorable or to deny you a favorable order. This is precisely what I did for a client of mine, which was a company around a couple of years ago. This particular company was facing an issue with its former distributor, who somehow felt that the company did him wrong. This distributor used to barge into any of the offices of the company. He used to trouble the salesmen of the company. He used to create havoc for everyone. The client approached me. Of course, I filed my criminal complaint for all the injustices that were meted out. But apart from that, I filed a civil suit for injunction and damages. The moment I went to court, I got thus the orders. I got a process server to serve the same, the summons for the same on the defendant. And since then, it has been about a year and a half. This man who used to trouble the company on a daily basis has not troubled the company, has not shown his face anywhere. Of course, the reason that happened is because the court granted interim injunction, and said that you will not contact anyone, you will not try to do anything without the due process of law. But the fantastic thing is, a ruffian, a goon like that, was brought to his knees by the process of the law with a few simple steps. Now this man, the case is still not decided yet because of judges on leave, certain facts here and there. The person forgot to file his written statement on time. So I filed an application that his written statement should be rejected, should be struck off the record. All of these things, the matter is still going on. It's been over a year and a half now. But the fantastic thing is the man comes to court with his tail tucked between his legs every single time and is very, very ready to settle things with my client and to not disturb my client. The lesson here is, as a lawyer, do not focus only on what you already know well. You also have to try your best to circumvent things and keep trying different things so that you can learn what else are the remedies that you can do for yourself and for your clients. But B, also take the most aggressive approach possible as an advocate, as and when required, to get your relief as soon as possible.